How did a single parent, tired of his daughter walking past a whites-only school, spark the legal battle that dismantled segregation in America? In 1954, Brown v. Board of Education didn't just challenge separate but equal. It declared it unconstitutional. This unanimous Supreme Court decision didn't appear overnight. It was the culmination of decades of legal strategy, a series of individual acts of courage, and meticulous argumentation. We're going to unpack the story behind this landmark case, exploring the precedent it overturned, the attorneys who risked everything, and the seismic shift it brought to American law and society in 2026. What exactly happened when Oliver Brown simply wanted his child to attend the local school? On May 17, 1954, a unanimous United States Supreme Court issued a decision that would fundamentally reshape American society. Chief Justice Earl Warren, speaking for all 9 justices, declared that separate educational facilities are inherently unequal. This single phrase, from the landmark case of Brown v. Board of Education of Topeka, signaled the beginning of the end for state-sanctioned racial segregation in public schools, overturning a legal precedent nearly 60 years old. The story of Brown is not merely one legal filing or a single decision. It is the culmination of decades of strategic litigation, brave plaintiffs, and tireless advocates like Thurgood Marshall, who would later become the first African-American Supreme Court justice. The ruling came after 2 rounds of arguments before the High Court, first on December 9, 1952, and then reargued on December 8, 1953, reflecting the immense legal and social gravity of the issues at stake. For generations, the doctrine of separate but equal, established in Plessy v. Ferguson in 1896, had provided the legal framework for racial apartheid across the nation. Yet, as this case would reveal, the reality of separate was rarely, if ever, equal. This decision did not just address school facilities. It confronted the very concept of racial hierarchy embedded in law. Its impact rippled far beyond the classroom, catalyzing the modern civil rights movement and inspiring future struggles for equality. But how did we get here? And what exactly did the court find? This video presents publicly documented information. It is for educational purposes, not legal advice. The landmark case, officially titled Oliver Brown, et al. V. Board of Education of Topeka, et al., commenced its journey to the Supreme Court with initial arguments presented on December 9, 1952. Following extensive deliberation and the submission of comprehensive amicus curiae briefs, the case was reargued on December 8, 1953, a clear indicator of the profound legal and societal implications simmering beneath the surface. Then, on May 17, 1954, a unanimous court, under the decisive leadership of Chief Justice Earl Warren, delivered its historic verdict. This pivotal decision unequivocally declared that separate educational facilities are inherently unequal, thereby dismantling the nearly 60-year-old, separate but equal doctrine, a legal fiction that had been upheld by the infamous 1896 Plessy v. Ferguson precedent. For instance, Oliver Brown's 7-year-old daughter, Linda Brown, was forced to navigate dangerous railroad tracks to reach her segregated black school, while the well-equipped, whites, only Sumner Elementary School was only 7 blocks from her home. The court's ruling legally ended decades of racial segregation in America's public schools, marking a defining moment in U.S. history by dismantling legal racial apartheid in education, a system whose roots stretched back through centuries of discriminatory legal precedent, with the shadow of Dred Scott v. Sanford still looming large. However, to truly understand the legal terrain of 1954 and the monumental task facing Thurgood Marshall and the NAACP, we must first look back nearly a century to a case that cast a long, dark shadow: Dred Scott v. Sanford. In 1857, the United States Supreme Court, led by the deeply divisive Chief Justice Roger B. Taney, delivered a ruling that profoundly shaped the legal status of Black Americans for generations. The court explicitly denied citizenship to Black people, regardless of whether they were free citizens living in northern states or enslaved individuals seeking their freedom. Chief Justice Taney's infamous statement, articulated in the 7-2 majority opinion, that Black people were a subordinate and inferior class of beings, with no rights which the white man was bound to respect, became a stark, chilling legal precedent. This decision, predicated on historical misinterpretations and racial prejudice, not only intensified national tensions over slavery, contributing directly to the Civil War, but also solidified a legal framework of systemic racial inferiority that permeated every aspect of American society. This bedrock of injustice had to be meticulously and courageously dismantled for any future civil rights advancements to take root, making the path to Brown v. Board of Education an arduous, uphill battle against ingrained legal and societal prejudice. The monumental task of dismantling segregation, as undertaken in Brown, stood in stark contrast to earlier legal battles, particularly the swift and decisive trial of abolitionist John Brown. Brown's own reckoning occurred in Charlestown, Virginia, just before the Civil War. His trial, Virginia v. John Brown, commenced in the Circuit Court of Jefferson County on October 25, 1859, with Judge Richard Parker presiding. A grand jury was immediately impaneled to hear witness testimony for the state. This initial process unfolded amidst rumors that Brown, an ardent Christian abolitionist who considered himself an instrument of God, intended to use the courtroom as a platform to publicize his motives following his raid on the federal arsenal at Harper's Ferry just 9 days prior. Despite Brown's desire to speak on the moral imperative of his actions, the proceedings moved with remarkable speed. The trial concluded on November 2, 1859, just over a week after it began, resulting in a conviction for treason, murder, and inciting a slave insurrection. He was subsequently executed on December 2, 1859. The swiftness of Brown's trial and its direct outcome stands as a powerful historical counterpoint to the protracted legal strategy that would eventually consolidate justice through cases like Brown v. Board of Education. Brown v. Board of Education wasn't one lawsuit, but a consolidation of 5 distinct legal challenges against school segregation from across the nation, argued before the Supreme Court in 1952 and 1953. Among them was Briggs v. Elliott from Clarendon County, South Carolina, where parents, led by Rev. Joseph A. Delane, sought equal busing and facilities. Their 1950 lawsuit challenged the disparity between white and Black schools as a violation of the 14th Amendment. Another pivotal case was Davis v. County School Board of Prince Edward County, Virginia, where students at Robert Russamotten High School, led by Barbara Johns, walked out in 1951 to protest dilapidated conditions. The NAACP then filed suit on their behalf. From the nation's capital, Bolling v. Sharp challenged segregation in D.C. public schools under federal law. These combined challenges demonstrated the pervasive nature of segregation, setting the stage for the court's unified ruling on May 17, 1954, that profoundly reshaped American law and society. This comprehensive approach to justice, then, leads us to consider how similar legal battles have unfolded, such as in cases like Ferguson and Michael Brown. Yet the name Brown echoes in more recent legal and social consciousness, albeit in a tragically different context. On August 9, 2014, in Ferguson, Missouri, the shooting death of 18-year-old Michael Brown by Officer Darren Wilson ignited widespread public outcry and intense debate over policing, racial justice, and the use of force. The immediate aftermath saw significant public unrest and a highly publicized investigation by local authorities and the Department of Justice. Court records and later interviews revealed a complex factual landscape. The grand jury ultimately decided not to indict Officer Wilson on November 19, 2014. Subsequently, newly released interviews from the Department of Justice investigation highlighted significant discrepancies in witness accounts. Of the more than 36 interviews, some previously undisclosed, many witnesses corroborated Wilson's claim that Brown struggled with him at his patrol car. A number of these individuals stated that Brown reached for Wilson's gun, offering a different insight into the events leading to the shooting. This tragic event, while distinct from the landmark school desegregation case, underscores the enduring, often fraught, relationship between the legal system and racial equality in America. From the divisive Dred Scott decision to the consolidation of cases that became Brown v. Board of Education, and the tragic echo of the name in Ferguson, Missouri, these legal battles named Brown v. illuminate critical junctures in America's ongoing struggle for justice and equality. They underscore how court decisions, whether establishing or dismantling segregation, profoundly reshape societal norms and individual rights, often with generations of reverberations. The pursuit of equality, as documented in these cases, is not a linear path but a complex, sometimes contradictory, journey through legal precedent and social upheaval. Given the seismic shifts these cases brought about, what do you believe is the most significant long-term impact that either Dred Scott or Brown v. Board had on American society that we still grapple with today? Share your insights in the comments below. To ensure you don't miss another deep dive into landmark legal cases and their enduring legacies, consider subscribing. And if you found this analysis compelling, you'll want to watch my breakdown of Plessy v. Ferguson next, to understand the legal foundations that Brown v. Board sought to overturn. This video presents publicly documented information. It is for educational purposes, not legal advice.